So guys, I am thinking. So as many of you know, I'm having a July 4th party at my house, and so one of the things
is our entire listenership invited?
Definitely not, because I don't know who some of these people are. And
I mean, listen, Ruch, if they can find your house, I think they should be invited.
So here's the thing. So I've decided that I would like to have, and this we hopefully will release this episode after the party, so it doesn't spoil it, but it'll spoil it for you guys. I'm hoping to have pocket constitutions to distribute, for anyone that wants one, obviously. And so I went on Amazon to look for a pocket constitution. This is like an hour or two ago, and the highest rated pocket constitution is only $1. And it's like 3,000 reviews, 4.5 star. And I was like $1. So I was like pretty ready to buy it. And I thought, like maybe I should just read some of these reviews, like what are people thinking about this pocket constitution? And I was like, maybe I'll get some good commentary on the Constitution itself. And so the biggest issue with this Constitution is some people are getting a Mormon church version of the Constitution.
What does that mean?
I don't know, but people are saying that they're getting the LDS Constitution as opposed to the U.S., like an LDS version of the U.S. Constitution. So,
like, what's different?
I don't know. They're not saying. So I'm obviously going to order this, and we can like discuss it on the next show as to what the LDS version of the Constitution is like. But I thought this would be like actually really good if you wanted to like engage in some propaganda, sell really cheap copies of the pocket Constitution. So when people are having 4th of July parties, they hand out your pocket Constitution, and then when people go home and obviously they read those pocket Constitutions, maybe they think that that there is no separation of church and state or something like that,
I thought there wasn't.
Yeah, dude, that's what Trinity stands for.
Yeah.
No, dude, we still have separation of church and state.
Did you read the cases? Like, we were supposed to talk about, the cases from the Supreme Court that happened
Yeah,
recently.
there actually is a case that we're going to talk about today that doesn't acknowledge the separation between church and state. Okay, so the Supreme Court is over. I mean, not like forever, although hopefully forever.
No, come on, AJ.
For the summer, the Supreme Court is like going to school. Like at the beginning of the summer, they take the summer off. Go to Europe, do a Euro trip,
which is exactly like the movies that you've seen about everyone else.
We've got some cases from the past term that may or may not be worth talking about, depending on what kind of things you like to talk about. And pretty okay, I guess.
Yeah, that's pretty much it.
Pretty much it.
I mean, so maybe we can also review what our batting averages are. So everybody knows that one of the reasons we do this podcast, in addition to the pleasure that we get from our listeners listening, is so that I can remind AJ how, being a non-practicing lawyer, I'm still doing a better job of predicting the Supreme Court than
Yeah,
he
I have
is.
the worst batting average out of all of us. That's true. Okay, all of this is crap. This is crap. The batting average thing is crap. Because I don't pay attention when Tom's describing the cases.
Hold on.
Who knew reforming healthcare was hard?
Yeah. I think when we get like David Fredericks or Neil Catal on this podcast, like predicting cases, and then you beat them, then I think you can brag about being a non-practicing lawyer.
Dude, I'm almost beating you. If not for the Supreme Court's last couple of decisions, I would be beating you. They found a way to screw me again.
That's my point, right? Like, is that, it's not as if like, AJ or I have some special Supreme Court expertise. Like we basically have similar backgrounds.
But Tom, you clerked for the Fifth Circuit, dude. Come on.
Yeah, and it wasn't on the Supreme Court.
Dude, but ostensibly you read some Supreme Court cases while you were there,
Nah, dude. Circuit courts don't read Supreme Court cases.
Circuit courts don't even read circuit court cases.
There are a lot of them out there.
Too many.
You can't
Most
keep
of them are
track of all that.
unpublished.
Yeah.
So anyway, I guess the important thing here is I'm beating AJ. in our and if not for the Supreme Court screwing me, I would also be beating Tom.
Yeah. And if not for the Supreme Court screwing AJ, he'd be beating all of us.
I mean, I suppose.
But so we have like 20, 30 cases.
Dude, we have 30 cases to talk about?
Yeah. No, not to talk about, but like we predicted the outcomes of 30 cases. It's a pretty big deal, right?
It is. And we're 20 episodes in. For our listeners that have been with us through all 20 episodes, thank you. For our listeners that, just started listening, where have you been? And for those that have only listened to 4 or 5 episodes, you have 16 episodes to catch up on.
Is that a lot?
That's a lot. It's a lot of homework.
Yeah.
But yeah, should we just delve right in? Should we talk about, should we just jump into what's happening? Yeah, some cases. And this will be kind of our review of some of the big things that happened this Supreme Court term. What do you guys think?
Well, I think the biggest case that came out, it was not one that we predicted. That was the Trump v. International Refugee Assistance Project.
Well, that hasn't been decided yet, right?
Well, no. But they granted, things have happened.
But things have happened. But I think we can preview.
Okay, so let's start our review of the previous term by doing a preview of the coming term.
Yeah,
let's do it.
Yeah,
let's do it.
Good.
Okay, so Trump did a Muslim ban. He was trying to ban Muslims from getting into the country. And the reason why, and I think it's fairly clear now, it's that he didn't want Muslims to come to the country.
I think he said that he didn't want Muslims in the country a few times. And in fact, blamed his own Justice Department for weakening his prior Muslim ban.
Wait, I can't find the order granting cert. Where is it?
It's in the show, or not the show notes. Well, it will be in the show notes, but if you go to the Google Doc, it's under cases to talk about.
Oh, okay, I see it. Yeah. Okay, so here's what happened. So Trump tried to prevent Muslims from getting into the country. You may be familiar. He did a Muslim ban, and a lot of courts have stayed the Muslim ban. And the reason why they stayed it.
AJ, what does it mean to stay a decision or stay the president's Muslim ban?
Yeah, well, that's a fair question, Ruchit, and I sort of think that if you were still a practicing lawyer, you would know what that was.
It was really for our listeners. I certainly do know, and honestly, it was more so to help our listeners understand why you are doing so much worse than I am. You know what I mean?
So the
you're just setting me up for these, AJ.
So what the court said is that you can't enforce the Muslim ban. So what did the Muslim ban say? It said there are 7, and then it was amended to say there are 6 countries where no one can come in. These happen to be majority Muslim countries. They even were denying citizens who were those countries who had U.S. green cards. A green card is something that lets you get in the country, so that gives you a hint about whether that was a good idea. So the courts all over the country, courts in Virginia, in Hawaii, in Washington, all said that this order can't be enforced. And the courts of appeals have also said that this order can't be enforced. And on the West Coast, on the Ninth Circuit, they said that the executive order isn't consistent with the Immigration and Naturalization Act. On the Fourth Circuit, they said it's not consistent with the 5th and 14th Amendments of the Constitution. And so there are different reasons that all come to the same conclusion that the president shouldn't be able to just ban Muslims. Fair synopsis so far?
Yeah.
So the Supreme Court has granted a review. They're going to take a look at this in the coming term on the merits. But in the meantime, there's a question of, well, what do we do with these injunctions or the state that came out of the states? So the Supreme Court has said that the executive order can be enforced with respect to what's the exact word? It's non-U.S. persons that lack a bona fide relationship with a U.S. person or entity, so that those people can be prevented from coming from these countries. On the other hand, if you have a bona fide relationship with a U.S. person or entity, then you can.
And then so the follow up to that is immediately after the court issued its order granting cert and staying the court's injunction below. The Trump administration released a new set of orders saying, okay, here's what it takes in order to have a close relationship, and only immediate family members. So if you're so basically what they're saying is that you cannot have a close relationship with your grandmother or your grandfather or your grandchildren. You can't have a close relationship with anyone outside of your immediate family member.
That seems fair.
Yeah.
It's I think that the dissent on this grant of cert petition, I guess, makes, I think, like one very good point, which is that sort of formulation is like largely unworkable, right? And it says, so for example, Thomas says, the compromise also will invite a flood of litigation until this case is resolved on the merits, as parties in court struggle to determine what exactly constitutes a bona fide relationship, who precisely has a credible claim to that relationship, and whether the claim I feel like the court would have been better off actually not. I mean, I feel like the court would have been better off just granting cert and not lifting the stay.
Yeah, that's the argument, right? Like, Thomas was using that to point out that the entire stay should be lifted.
No,
but
I
that
know.
Right? Like, all Muslims should be banned completely. Or not. I mean, that's an exaggeration, but yeah, he was using that argument to say that the entire stay should be lifted, but that argument is just as good for keeping the entire stay and preventing the Trump administration from banning anyone while the court decides.
Yeah, I mean, that was his argument. I think the other thing is if there are like true national security issues, and this is the reason why supposedly you're banning everyone from these countries, will there actually be fewer national security issues if they have a bona fide connection to the United States and a relationship here? Like, that doesn't actually do anything as it relates to the question of, is there a national security issue or not? You know what I mean?
Well, yeah, and the other thing that I would add to that is that this does not prevent the administration on a case-by-case basis determining whether there's a national security issue. It's not like, the leadership of ISIS automatically gets a grant of admission into the United States.
That's right. Everybody still has to go through the normal procedure. It's not as if, yeah,
and that process involves screening for making, for individuals we don't want that are going to harm our national security interests.
Yeah.
So
what do you guys think? Let me ask a question, AJ. What do you guys think about how this sets us up for when this case is actually heard before the court? Like, when you were reading this or reading about some of the commentary about this, was there anything in particular that stood out of suggestions of how the court is likely to view, some of the arguments that were made in the lower courts?
Well, so I think the composition on this order is super interesting. So the order is per curium, which means you don't actually when the order of the court is a per curium order, nobody signs it. So you don't actually know who signs on and who doesn't, right? If you have a per curiam order, and let's say there are no concurring or dissenting opinions, right? All you know is 5 people voted for it, and you don't know which 5. And it could be 9-0 or it could be 5-4, and you wouldn't know because it's per curiam. So here we have a per curiam order that has this bona fide relationship framework. And then we have a 3-judge dissent. And the 3 judges in the dissent are Thomas, Alito, and Gorsuch. And so you know that, and the premise of the dissent is that all of the injunctions should be lifted, not using this like bona fide relationship framework, but just all the Muslim ban is good to go. No Muslims, please, dear God, no Muslims. That's basically the premise of the dissent. And so we know for sure that there are 3 votes that would overturn these lower court injunctions. And one of the key things is that there's some back and forth between the per curiam decision and the dissents about how, you go in and you mess around or you alter injunctions or you grant injunctions in the first place based on who's likely to succeed on the merits. And the three judge dissent comes out and says, we think that the United States is likely to prevail on the merits, and that the Muslim ban is going to be upheld by the court. That's what the three judges in the dissent are saying. So you know that there are 3 votes for sure to uphold the Muslim ban. And then you really have no idea who comprises
the other 2?
Or
more, I guess.
The other, where the other 6 are. You have no idea who comprises the 5 votes for the per curiam order. It's the other thing to keep in mind is that it takes 4 votes to grant certiorari. So you don't even know who. You don't even know
there are
vote.
5. You just know there are 4.
No. You know there are 5.
You know there
are 5 because there are 5 votes. It takes 5 votes to change the injunctions. It takes 4 votes to grant cert. Right.
So you know there are at least 5 votes. Well, is it possible that there are well, no, I guess you're right. So there have to be 5 votes that think it's likely that the government will prevail on the merits and that the government has been harmed or is likely to suffer irreparable harm.
Right.
Is that right?
Yeah.
So doesn't that mean the government's going to win this? Almost certainly?
No.
Okay.
Explain to me why you think that there has to be 5 votes that think it's likely that the government will prevail on the merits.
Because isn't the lifting of the stay, isn't the argument there that the government is likely to prevail on the merits and will be irreparably harmed if the stay remains in place? Or am I getting that wrong?
It doesn't have to be both.
Oh, I thought it had to be both.
No. I think in order to get a stay, it has to be both, right? Like in order
to lift it, you just have to. Oh, I see. In order to lift it, you have to say, "Listen, there isn't." Oh, okay. I think I get it. So then there are at least 4 votes.
Well, there are 5 votes to issue the opinion that the court have issued. We just don't know which 5.
But you're
of
saying,
the members of the.
But you are saying there's at least 4 votes that think the government is likely to win, or can we only say that it's just 3, which is Alito, Gorsuch, and Thomas?
I think as a matter of logical necessity, there are 5 votes who think that it doesn't matter whether this stay is imposed or not in terms of injury analysis. You know what I mean? I think you can read the opinion and you can get a better idea, maybe.
Yeah. I read it and I didn't really get any better idea.
So here's what I think, and I think Tom disagrees with me. I think that if you assume that all 6 of the remaining justices voted in the per curiam, or at the very least 5 of them did, right? So you've got Roberts, Kennedy, Ginsburg, Breyer, Kagan, Sotomayor, I sort of listed those in order of probability, right? I really think you're going to end up with like a 6-3 vote that basically comes out on this outcome. Like I think the court on the merits is probably going to split the difference, and you're going to end up with this bona fide relationship framework. And here's why I think that. I think that there's a standing issue that is probably persuasive even to the liberal justices, which is that the courts below that have been issuing these injunctions, the harm that they're finding that the injunction is necessary to resolve isn't the harm to people who are trying to enter the United States. And, considering that a lot of these people are refugees, et cetera, the harm is to U.S. persons. So the harm is to universities that want to employ these people who are visiting the United States.
So bona fide connection.
The harm is to the people who have the bona fide relationships with the people who are seeking entry into the United States. The harm happens to the universities that want to employ them, or to the family members that want them to visit, or whatever the case may be. And so I think that for the people that lack a bona fide relationship, basically refugees and tourists, I think the court is sort of much less sensitive to those people, which is sort of heartless, but it is what it is. But I think also the court is much more skeptical that those people have standing or are going to suffer harm that the court needs to remedy.
Yeah, I don't know if I necessarily disagree with that. as a prediction of the ultimate result of the case. I guess the only bone that I would pick with you is that we can know exactly where folks on the court stand on this issue at this moment. I just don't think you can tell from this opinion,
Yeah, I couldn't tell much of anything, honestly.
You have no idea who has voted for the per curiam.
Yeah.
And it even could be that the 3 dissenting justices also voted to comprise the 5 judges for the per curiam order. So you really have no idea. But it is super interesting. I don't know. I think Tom disagrees with me. I think Tom doesn't think that as many as 3 liberals believe in this bona fide relationship framework.
Mm-hmm. No, I think that's possible. I just don't, I just don't know if that is the case yet. I think that so the bare minimum in order to get this opinion issued, right? You could have Roberts, Kennedy, and then signing on with them, Thomas, Alito, and Gorsuch, right? The latter 3 may want a broader lift of the stay, but maybe Roberts and Kennedy are saying, no, we want it narrower, right? So in order to get that narrow lift of the stay, the 5 could issue that initial per curiam opinion of the court, and then the latter 3 could write their concurring in part, dissenting in part, saying, no, it should be broader.
Yeah. I mean, we don't know. Anyway, this is super interesting. I don't support the Muslim ban. And so, I hope they do the right thing.
Yeah.
Well,
we'll see.
I don't support it either, and I hope they put the kibosh on it. I don't know. It's a lot of when I see things in the Trump presidency, I just wish there was some unity against these ideas instead of kind of trying to split the baby on these various legalisms. You know what I mean? And I think so it'll be interesting to see where the Supreme Court comes out on that. Do they give the man a partial victory, which he turns into a full blown one? And then obviously, you give him an inch, he'll take a mile kind of situation.
Mm-hmm. Well, and I tend to agree with AJ in the sense that relationship test is probably going to be the ultimate result in this case, given the makeup of the court. But I wouldn't be surprised to see a few of the liberals dissent on that, and say that it shouldn't be a relationship test. It should just the injunction should be a permanent injunction. And it based on the idea that when the government acts in a discriminatory manner based on religion or ethnicity or that sort of thing, the government can't take unconstitutional action in that manner. Because in essence, what we're saying, let's assume for the sake of we can debate whether or not the Muslim ban is racist or not or whatnot, or discriminatory based on religion or not. But let's assume that the lower courts have gotten it right on that front, and the lower courts are, because this is not a circuit split issue. This is not some lower courts are saying, this is discriminatory, and other lower courts are saying this is not discriminatory. All of the lower courts that have addressed this issue, including conservative lower courts, have said that it's discriminatory. In essence, what this relationship test is saying is that you can discriminate against people based on religion or their ethnicity so long as they don't have a relationship with the United States.
Yeah. I mean, I think that's precisely what they're saying.
So if you were Trump and you're playing the long game on this one, which he certainly isn't, eventually, if you don't let any more Muslims into the country, there won't be any Muslims left, or very few anyway, and then there won't be any relationships with the country. So if there isn't a free flow of people, how are you supposed to develop a relationship with anybody? Does an internet relationship count? I don't know.
Should we move on?
I guess,
okay.
If you want.
I have a case that we actually is from the term that we're reviewing, so it's actually a step closer to the topic of the show. But it is not one that we did our predictions on. But I want to talk about it really quickly because
let's talk about it really slowly, dude. I mean, it's fine. It's a topic of the show.
No, I want to talk about it. I want to talk about it really quickly. I'm like real hopping mad about Gorsuch.
Oh boy,
what case is this?
This is Paven versus. Let me see if I can find. Yeah, Paven versus Smith, on petition for writ to the Supreme Court of Arkansas. So
this case.
Yeah, this case, right? So the facts here are basically that the in Arkansas, right? So the Obergefell decision came out, and it said that same-sex marriage is required by the Constitution, and not only are they required to be able to get married, but they have to be able to get married on the same terms and conditions as opposite sex couples. So I think the clearest interpretation is that they are entitled to the same sort of rights and privileges that opposite sex couples are. And so in Arkansas, there was a question about, okay, so there's a child who was born to a woman who was married to another woman. And so they had found a sperm donor, and one of them had actually been pregnant and carried the baby to term. So on the birth certificate, unquestionably, one of the parents, right? Because the baby came out of her. And then there was a question on the birth certificate, is the recording agency, Mr. Nathaniel Smith, was he allowed under Arkansas statute to put the mother's spouse on the birth certificate as the other parent? And the Smith said, no, the statute prohibits me. And it went all the way to the Supreme Court in Arkansas. And the Supreme Court in Arkansas said that, that there are legitimate biological and policy reasons for not listing the same-sex mother of this child on the birth certificate. And it's a sort of horrible decision out of this state Supreme Court. And in Gorsuch's dissent, he sort of tries to hand wave away this problem. And I think that there are two things that he's saying. So the first thing he says is that it's pretty clear that he is sort of sympathetic to this idea that there is a legitimate biological or policy reason for states to have this sort of policy. But the second thing he says, which to me is just ridiculous, he says the state has repeatedly conceded that the benefits afforded to non-biological parents under the Arkansas statute must be afforded equally to both same-sex and opposite-sex couples. So in this particular case, and all other of its kind, the state agrees the female spouse of the birth mother must be listed on the birth certificate too. And he's sort of saying this as a way to like hand wave away the problem, like, oh, Arkansas is not really so bad. And you read that, and it's like totally inconsistent with the fact that if that were the case, if the state really had conceded that they were required to list this on their birth certificates, then why is there a case? Why is the appellant appealing? Why did the Supreme Court of Arkansas not make the state do it? And it turns out that the Smith had made an argument that some other statute was invalid, not the statute that controls birth certificates, not the statute that is actually being challenged. But he said that some other statute was invalid. And in the court below, the Supreme Court of Arkansas said, well, we're not going to, that hasn't been briefed. It hasn't been argued. It's not the statute that is subject to appeal. There's no preservation of appeal with respect to that statute. And so we're not going to rule on it. So basically Gorsuch is saying that this argument that wasn't ruled on or preserved for appeal in the court below disposes of the case as a way to sort of, I mean, I don't even know what he's trying to do. I mean, do you have a reading on this? It's hard for me to tell. He's clearly not stupid, which makes me think he's trying to do something. But when the thing that you're trying to do is so inconsistent with the facts of the case, it's hard for me to figure out where he's going or why.
I don't know what he's doing. Actually, I mean, the only guess that I have is that he's trying to pretty up views that most Americans disagree with. Because if he just went out and said, or if most people went out and said, listen, I don't think gay people should have rights, I I think at least in today's day and age, that would be a tough view to have in polite society in America. And to me, this is a lot like back in the 2000s, right at, kind of 3 or 4 years after 9/11, when there was a Muslim group that wanted to build a mosque. Do you remember the Ground Zero mosque debate? Do you remember that? And so they wanted to build a mosque, and it was like 4 blocks from Ground Zero or something like that. And of course, most people in kind of the hard right that were on TV were not willing to say, hey, Muslims shouldn't be able to build mosques in this country. We hate Muslims. And so instead what they did is they say, well, it's just so insensitive. Why don't they just build the mosque a few miles away? It's a sensitivity thing. Let's just be sensitive, And it's the same type of thing where you try and put a pretty face on what is really just kind of a bigot-laced argument, right? And so
isn't that the entire GOP recently?
I don't know. I think that's what Gorsuch is doing here. I think
Ruchit's right. So here's a line from what he's saying. Before the state Supreme Court, Arkansas argued that rational reasons exist for a biology-based birth registration regime, reasons that in no way offend Obergefell. In an opinion that did not in any way seek to defy, but rather earnestly engage Obergefell, the state Supreme Court agreed. It is very hard to see what is wrong with this conclusion. For, just as the state Supreme Court recognized, nothing in Obergefell indicates that a birth registration regime based on biology, one no doubt with many analogs across the country, blah 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 blah. So, I think Ruch is actually right. I think he's trying to pretty up these positions that are inconsistent with the spirit of Obergefell.
In Texas, we called that putting lipstick on a pig.
But I really think he's trying to. It's two things, right? Like, one, he's trying to carve out this like respectable place in society for people who want to narrow out the Obergefell decision, right? So he's saying, oh, this Arkansas Supreme Court isn't defying Obergefell. They're trying to earnestly engage with it, but they're earnestly engaging in it with it in a way that narrows the purpose of the decision, right? It's inconsistent with the spirit of the decision. And I think he's trying to lay like a legal framework for states to do this, but he's also trying to make the argument that these people aren't so awful.
Well, I was going to say that on that same day, the Texas Supreme Court issued an opinion called in the case Pigeon v. Turner. It's a case that comes out of Houston. Basically, the city of Houston wanted to give same-sex couples the same benefits as heterosexual couples, and these two individuals sued the city of Houston, saying, "No, you can't do that." And the Texas Supreme Court agreed with these two individuals.
I can't believe these people had standing.
Well, these are all issues, but the point that and I think AJ, when I sent this to you, you said that the Gorsuch opinion sort of lays out the framework for doing something like this if lower courts were so inclined
yes.
to do it. But the bigger point that I would also make is, what is the point of having an opinion saying that same-sex couples have the equal right to marry if on the back end you're saying, yes, you have the equal right to marry, but the definition of marriage for you is going to be different than the definition of marriage for other individuals.
Well, that's the future Gorsuch wants for America.
I think it's really he's trying to do two things, like, and this is kind of what a good lawyer can do with language, right? Is you can make it a respectable position, right? Which is what the state of Arkansas is earnestly testing things, as if the state of Arkansas intention is, well, oh shucks, we're just trying to figure out what Obergefell means, It's, we just want to know what it means, and so here we are. We just want the court to tell us what does it mean, and no, that's not what the state of Arkansas is doing. I'm sorry. Go ahead, Tom.
On that point, right? If you read Gorsuch's opinion, right, it says. It starts out, summary reversal is usually reserved for cases where the law is settled and the facts blah, blah, blah. Basically, summary reversal is a very strict standard is what he's saying, right? And he's saying that this case doesn't meet that standard for summary reversal. So let's give him the benefit of the doubt and assume that he believes that the lower court erred, right, with regard to Obergefell. But his position is that error isn't so great such that summary reversal is warranted. Well, what do you do when a lower court errs, with regard to an opinion, previous opinion of yours, if not reversing that error? Do you hold arguments? Do you
well, I think
wait several years and
he would have wanted them
then?
to vacate and remand, right? So that it would have to work its way through the court system over another year or so before these people finally got the birth certificates they wanted.
I think it's bigger than that, actually.
I mean, vacate and remand how? Like, what does vacating and remanding do, right? He would the court would issue an opinion saying, look, I think you lower court erred with regard to Obergefell. I'm going to send this back to you. You guys redecide this, and then come back to us. Like, what is the practical difference?
So I'll tell you what
I mean,
Tom. I'll tell you what it is. I think it's that he would have preferred that the issue of same-sex marriage be, if not relitigated, have so many limitations on it, so as to make it meaningless. And
no,
if the court,
I understand that.
If the court had, instead of, think of how much more complicated this would make it for the court, right? The decision that they send when they do a summary reversal, hopefully the indication they send to lower courts is, listen, stop trying to f*** us. Like, we've made it very freaking clear.
That's correct.
That's
correct.
We've made it very clear, and we're not going to have you come up here every single day and tell us, well, we were restricting it as it relates to the birth certificates, and you said that wasn't okay, but now what if we say that the birth certificate, we only want to issue it, we want to wait 2 years before we issue it. What if we
want to make sure that this same-sex marriage really survives the long term?
Exactly, because we have these beliefs that maybe same-sex marriages won't survive, and we just want to protect the kids, and it just bullshit after bullshit, right? And I think that's, if you're on the hard right and you believe what Gorsuch likely believes in this situation, that's a litigation posture that's much more interesting for you, because that's what's happened on Planned Parenthood issues, right? On abortion issues, it's been the exact same thing. It's the chip away approach as opposed to the wholesale reversal, and that's what Gorsuch is trying to lay the groundwork for, I think.
Well, no, I agree with you. Gorsuch wants a different result, right? But what my point is that the argument that he uses, the lipstick that he's putting on this pig, isn't even lipstick. Right? His logic that summary reversal isn't warranted here. We should and I'd like to point out, he doesn't even say we should remand and have them reconsider it. Right? He doesn't go that far. He makes no suggestions in this opinion whatsoever as to what, if the court is wrong, what the appropriate remedy should be when the lower court errs like it did. Right? We're just giving him the benefit of the doubt, saying, okay, well, if the lower court errs, then the appropriate remedy should be remanding it so they can issue another opinion. But practically speaking, there's no difference, Yeah.
Yeah.
And that's setting aside the fact that I think this was a clear error on the lower court's part.
This is sort of tactically what he's doing or what he's suggesting is consistent with his beliefs.
The other point that probably is worth mentioning is that the justices who joined Gorsuch, Thomas and Alito, comprise the same three justices that would totally uphold the Muslim ban. I think that sort of
AJ, that's not fair. I mean, I think they really just care about summary reversal. That's just a very important procedural doctrine that they worry about day in, day out, and
keeps them up at night.
It does, and when they're on their 3-month vacation in the summers, they're like, damn, that summary reversal doctrine, when am I going to get my handle on that, and this was an opportunity to do so.
It's just chaos in the lower courts.
It is, dude. It is. They just can't function, And
Well, yeah. What else is news? What other cases you want to talk about? Tom, you've got like a bunch here.
I just put some that thought might be interesting. I think maybe one of the more interesting ones might be Hernandez v. Mesa. This was the case where Officer Mesa was a Customs or Border Patrol agent who shot a child who was playing in a culvert on the U.S.-Mexican border. And the entire issue was, well, he was on the Mexican side of that culvert, and does that mean that he can sue Mesa in civil court for remedies for having shot him? And the court, in a per curiam opinion, said that it should be that. Basically, I guess this is, in this per curiam opinion, they're doing what we were giving Gorsuch the benefit of the doubt in the previous opinion. It was a very narrow decision, remanding it, vacating the lower court, remanding it to the lower court, saying, you guys erred. You need to redecide this case. Here's some guiding principles by which you can redecide this case. So they were kicking the can down the road, in essence.
So I think if our listeners want to get a good, easy taste of Supreme Court jurisprudence without, maybe arguing in front of the Supreme Court, reading per curiam opinions is actually a pretty good way to do so, because they tend to be pretty short.
Yeah, they are. Oh, and the other thing about this case that I thought stuck out in my mind was, AJ, we were having a discussion in the Slack a while back about how whether courts consider evidence on the record or whether they go outside the record. And I think, this is an example of a court actually going outside the record, because the posture of this case, this was the lower court dismissed it on the pleadings, which means that the lower court basically assumed everything that Hernandez, the little boy, or his estate was saying was true, and said, even assuming all of that is true, you don't have a case, right? So when that comes up at the appellate courts are basically supposed to do the same thing. They're supposed to say, even assuming what Hernandez said is true, you either do or do not have a case. You either can or cannot go forward, right? At the Supreme Court, you're supposed to take the same posture, but here you have the Supreme Court pointing to, for example, a DOJ investigation, which was not part of the record. They basically say, see this DOJ investigation, which was published online, and we can link to the investigation on in the show notes, I guess.
Interesting. That's actually super interesting. I hadn't caught that when I was reading about this.
So I don't know. I think I bring that up because I think it's a interesting thing to think about, right? Like, because the reason courts are supposed to only consider the record below is because there's an evidentiary process to making sure only reliable evidence gets into the record, right? That's the rules of evidence. But as you go higher and higher in the courts, right? I find that these courts do stray from the record when they can reliably, when they sort of know that the evidence is reliable, or that when they it's almost like they're taking judicial notice that the evidence is reliable. So another example of this is the Trump tweets in the immigration context with regard to the Muslim ban. A lot of the intermediate courts, even though those tweets were not entered into the record.
I thought they were in the record.
Well, I think in some cases they were, in other cases they were not. And Trump tweets all the time, so they're able to.
You can't have a full record.
Yeah, they're able to pull much more recent tweets, right? So, that's that. I mean, technically, and I guess practically as well, those tweets are evidence, right?
Yep.
And so in order to get those tweets into evidence, you would, under the rules of evidence, you'd have to consider, okay, well, they're hearsay. Are there any exceptions to hearsay? Are they reliable? Blah, blah.
They're statements of a party opponent.
Yeah. But that's not the point, right? My point is that when you get higher and higher in the courts, it seems like the courts say, well, I know that it's hearsay, but this is from a verified Twitter account, therefore it's reliable, and I don't need
that
to worry
blue
about
check mark.
Yeah, that blue check mark.
I seriously. So okay, this is a side. This is a digression. In the rules of evidence, there is something called authentication. So basically, evidence has to be authentic. There are two ways that evidence can be authentic. You either need some sort of sworn statement from someone who says it's authentic, and somehow that statement has to not be here, blah, blah, blah. Usually someone on the stand is like, oh, I'm present in court, and this is a photograph I took, and I know where I was when I took it. But the other way that something can be authenticated is if it's self-authenticating. So government documents bearing the seal of the government and with the signature of someone authorized to issue the document is self-authenticating. And I sort of think that blue check marks should be self-authenticating.
Maybe. I mean, they don't, technically they don't get, that's not a government seal, right? That's a Twitter seal.
But what's the difference between our tech companies and our government? I mean, think about the role that Facebook plays in most people's lives and tell me how that's different from some sort of world government.
Yeah. Well, I guess. I mean, but at the end of the day, there is this gray space, where I think courts are much more forgiving of outside the record stuff when they personally think that it's not unreliable.
My computer's acting up. My trackpad and my trackpad of my hard drive just disconnected. I can't click, Tom. Dude. I can't click because my trackpad disconnected.
Can we have a show anymore?
I can't click.
Are we still allowed to have a show?
I'm here. My internet's great. My computer's working. It's pretty great.
How's the boom arm?
It's I have an arm, and I've put a
my computer's just totally frozen. Can you hear me?
Yeah, we
dude,
can hear you.
We hear you great, dude.
My computer's just not doing anything.
Your connection's as good as ever, AJ.
Yeah,
I can talk to you, but I can't manipulate any feature of my computer.
You don't? Do you need to?
AJ, have you gotten a new Mac product recently? This could be as a lack of it's been too long, maybe? Has it been maybe a couple of weeks at this point? Or
how's your new iPad?
The new iPad is very good. I used it in court. It was excellent.
Yeah.
So what's the next case? What else do you want to talk about?
Well, you guys pick.
Let's do the church. Let's do the Trinity Church. We can talk about footnote number 3, which we talked about in the pre-show that I'm probably not going to put in the show.
Okay.
Dude, I don't know a lot about footnote number 3. I'll be honest.
So this was, Trinity Lutheran Church v. Comer, this was the case where the state was offering this public program to public services that allowed you to resurface playgrounds and stuff. And the church wanted some of that money to resurface its playground. And the court held, the decision of the state not to allow the court, or not to allow the church money, or not to give the church money, is a violation of the Constitution. And the court, this was a 5-3 decision, I believe, right? No, 7-2 decision. This was a 7-2 decision with Sotomayor and Ginsburg dissenting, and the majority opinion had everyone else except for Thomas and Gorsuch, who dissented with regard to footnote 3. And with regard, footnote number 3 basically says that this case involves express discrimination against based on religious identity. And Gorsuch is saying that's an unnecessary. Thomas and Gorsuch are saying that's an unnecessary distinction.
Well, there's more to footnote number 3 than that, right? But footnote number 3, I mean, because part of what's going on in the case, right, is that the majority, the opinion of the court paid some sort of distinction between state funds used for resurfacing your playground, which has this child safety angle and blah, 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 versus money that goes to churches to use in conducting religious services. But anyway, keep going.
No, I mean, that's pretty much it. And, Gorsuch and Thomas would have gone broader than that, broader than and would issue an opinion based based on not just express discrimination on religious identity.
If this ends up becoming, so the end of the opinion is interesting. The Missouri Department of Natural Resources has not subjected anyone to chains or torture on account of religion. And the result of the state's policy is nothing so dramatic as the denial of political office. The consequence is, in all likelihood, a few extra scraped knees. But the exclusion of Trinity Lutheran from a public benefit for it is otherwise qualified solely because it is a church is odious to our Constitution all the same, and cannot stand.
Wow.
That's John Roberts, people. I actually don't know how I feel about this. I haven't read this opinion. I've read about it, I guess, a little bit, but I don't know how I feel about this. How do you guys feel about this? At a high level, at the beginning, and then we could dig into whatever weeds we wanted.
Well, I think your question needs a little bit more framing than just how do you feel about it, right? Because if your question is, given the Supreme Court's jurisprudence on religious discrimination and free speech, was this the right decision? Yeah, I think probably so, right? Because the whole idea, in the First Amendment grounds, there's this idea that if the state opens a forum, right, with regard to speech, and allows individuals that are secular to use that forum, then they must also allow religious institutions to use that forum as in equally as the secular, right? And secular, and by secular, we don't mean just like the atheists, right? Anything that is not religious is secular in the Supreme Court's jurisprudence, right? So if the court, if a state allows a school cafeteria to be used as a meeting grounds for like the Girl Scouts of America or for future scientists of America, then they must also allow an equal opportunity for religious institutions to have access under the same criteria and all of that as the Girl Scouts and the scientists. Does that make sense?
Mm-hmm.
Yeah.
So if you think about it in that context, here you have a state, right, that is allowing secular institutions to access to money to do things like resurface playgrounds, right? And they are expressly saying the only reason I'm not letting this church, Trinity Lutheran Church, resurface its playground that is for public use is...
Well, and to be clear, it's not like they're prohibited from resurfacing. That's
true, right? But they just don't have state funds to do the resurfacing, right? And so I think viewed in that framework, I think the opinion makes sense. Now there could be other frameworks that you view it that where the opinion doesn't make sense, right? Like, do we want does the First Amendment authorize the state to give taxpayer money directly to religious institutions in this manner?
Well, but I mean, I think the thing that is interesting about, particularly about Gorsuch in this case, is that it seems like he doesn't think that there's any moment in time when it would be reasonable for the state to discriminate against a church in giving out public money. Whereas the majority, the opinion of the court, does seem to think that if it went directly towards supporting religious services or religious worship, so if it were like money to, get new pews in the sanctuary or whatever in the chapel, then I think the opinion of the court would say then yeah, Missouri doesn't have to give them money to redo their chapel. But I think Gorsuch says yes. If you're going to have a like facially neutral program, if you have any sort of program, sorry, not facially neutral, if you have any sort of program that gives out government money, you have to give it to the church. Which I think is, I don't know. I think this is another case of Gorsuch being sort of on the extreme here.
Yeah, well, I think that limitation, and it's not even a limitation, right? Basically, all the court did is reserve for a future day deciding that issue. You know, they didn't decide it in this case. And you know, can we think of examples of situations where you might want to give money to the future scientists of America, but not to a religious institution? Maybe the publishing of literature, right? Like,
sure.
If you have these, you know, like a quote unquote secular group trying to publish literature to inform people about, you know, global warming, or inform people about how their taxpayer money is used, right? Like, I could see an example, like in that situation, you know, it would be appropriate for the government to give money to a nonprofit to do that sort of thing, but it would be inappropriate maybe to give money to a religious institution.
I have an example,
to publish literature. Yeah, go ahead.
What if you're the government and you'd like to distribute copies of the Constitution of the United States, and you know, you have these non-religious organizations, and then you've got some religious organizations, and maybe the religious organizations, you're not sure if they'll distribute copies of their version of the Constitution of the United States or the actual Constitution. And so, you know, maybe the government wants to say, you know, we don't want to worry about having to check every copy of the Constitution that goes out. You know, these are the things. I mean, I think this is just the beginning, which is probably not a unique opinion, but I think this is the beginning of this area of the court's jurisprudence in terms of what more things can be.
Well, particularly if Kennedy retires.
Yeah, for sure. Guys, I gotta go.
Why?
Yeah. What?
Dude, my dad's about to show up, like in a couple minutes here.
Put him on the show.
Yeah.
I would,
Do you have time for sidebars?
I have time for sidebars. Let's do the sidebar real quick. I've got mine. I'm ready.
There's one other case that has a Gorsuch angle to it. I don't know if we want to talk about that. That was the Miss Lenjak case. You want to quickly talk about that? This was the case where the question was whether, you know, if you
I remember this case.
Yeah. If you lie in the process of getting your citizenship, can the government revoke your citizenship based on any lie, or does it have to be a material lie? Does the lie have to cause you to get that citizenship requirement? Do you remember that?
I do remember this case.
Yeah. And basically,
this was the Trump's taking away all of our citizenships case. If the court decides that any last traffic ticket that we got is but forgot to disclose is enough to make us non-citizens.
Yeah. So basically, everyone, you know, concurred in the judgment that there should be some causal requirement, but the Gorsuch, Thomas, and Alito, I don't know if you remember that group from any other cases we've discussed previously, filed a concurring and opinion in part, and concurring with the judgment, saying, you know, we agree with the causal requirement, but we would remand because the test of whether, you know, an unlawful act could be unlawful in other circumstances is too broad. There's too much dicta. It's a step too far. I feel like in a lot of these cases, these three individuals' dissents, or not dissents, but concurring in part or concurring in the judgment opinions, are very much like, you know, I agree with the result the court reaches. I just don't like the way they said it.
It's pretty funny.
Which, to be fair, is what judges do. I think they just they go further than just that. I think they try and insert landmines for the future, you know, because they don't want to actually they don't want to openly dissent. I mean, that's kind of like the thing that you could appreciate about Scalia, I guess, is if he dissented, you knew it. You know, he wasn't going to do this bullshit where he would concur in part But actually he wasn't concurring at all. Whereas I think you see that a lot with Gorsuch is in there's a feigned I want to be careful in saying this, but there's a feigned sincerity when really he should just come out and say what he thinks instead of dressing the shit up.
He's still very new in the court. I mean, maybe give him a year or two. Maybe he will come out and say what he thinks.
Yeah.
All right. I have a proposal.
Yeah.
Here's my proposal. We do one quick question and then sidebars, and then we get Ruchit's dad on the show. You ready?
What is the question about what?
Here's a quick question. There are 9 justices on the Supreme Court. After seeing how Gorsuch has done the last few months, where would you rate Gorsuch among the 9 justices? I think you just pick a number. Pick a number 1 to 9. So how many justices do you think are worse than Gorsuch?
1.
Ooh, interesting. I'm gonna guess Thomas or Alito. I'm gonna guess Alito.
Alito for me.
Alito. Okay, Tom?
Yeah, I think 2. I think both Alito and Thomas.
I agree with Tom.
I would say give him some time, right? Like, he's still very new on the court, so maybe after, like, I still have hope for him, right? Like, I still
in the sense that he will be the one you're most ashamed of, or
no, I think he'll climb in the rankings, right?
In Stevens' first term on the court, he was the 5th vote to reinstate the death penalty in 1976, and he turned out to be a pretty decent justice overall.
Mm-hmm. So who knows? Who knows? I mean, we might be prejudging him a little bit here. We should maybe give him a little bit more time. I don't know. But right now, I do agree that him, Thomas, and Alito have formed this triumvirate.
Yeah. Sidebar. Do you want to hear my sidebar?
Yeah. Do it, dude.
Okay. I'm using my iPad. I remoted into my computer so I can control my computer and pull up my sidebar. I'm controlling my computer using my iPad as like a VNC. Okay, so my sidebar is an article in the New Hampshire Union Leader. So I think a lot of jurisdictions have been contemplating these sort of like fetal homicide bills. The idea of classifying certain abortions as homicides, just to like really emphasize fetal personhood. Anyway, so there was this bill working its way in the New Hampshire legislature, and it actually got voted out of the New Hampshire Senate. And the bill was a fetal homicide bill, and so it was adding certain abortions to the definition of second-degree murder. And they wanted to make an exception for pregnant mothers who like were getting legitimate abortions not to be charged with murder, but there was a drafting error, and so they just said that no act or omission of a pregnant mother or her doctor can be punished under this statute. And the statute that language referred to was the second-degree murder statute. So it was the second-degree murder statute does not apply to a woman who is pregnant. Wouldn't that have been dope? Wouldn't that would have been good, right?
Yeah. So like, women can go around killing people
as long as they're pregnant. Anyway, the bill got,
and only in New Hampshire, right?
People figured out what happened, and the bill didn't make it out of the House in that form. They cleaned it up, but just goes to show the New Hampshire's a weird place.
New Hampshire is a weird place.
It's like an upside down Vermont.
I like New Hampshire.
That's my sidebar.
Do you want to hear my sidebar?
Yeah.
So one of Apple's big marketing campaigns is the shot on an iPhone campaign, right? Like they'll display these like really pretty pictures that were taken using an iPhone, and they'll be like, "Look, if you had an iPhone, you could do this too," right? So Marquise Brownlee, do you know him? Marcus, is that how you say it? Marcus Brownlee?
Marcus Brownlee.
He goes by like MKDH something, blah, blah, blah.
MKBHD.
Yeah, on the YouTubes. He like broke down all of the tech required to shoot on an iPhone, and like I'll put this picture in the show notes. It's pretty crazy. Like it's like this like iPhone attached to like this giant like stabilization rig with like a cinematic lens attached to it with all these wires and coming out of it. It's good. It shows you like anyone can do it as long as they have all this equipment.
I always thought the shot on iPhone campaign was like really just someone shooting with an iPhone.
No, it's
I didn't realize there was
apparently
like people had
not.
like gimbals and stuff.
Yeah, if you click the link on the, if you can remote into the Google Doc and click the link, you can see this picture, and it's pretty crazy.
All right, I'm using my iPad as a trackpad right now.
Dude, you need to just get you need to remote in from your iPad to another iPad to your computer. You need to get super meta.
So this might actually be a real problem. It looks like Bluetooth just doesn't work on my Mac Mini.
Oh no! Does this mean you have to get a new iMac, dude?
I think I need to get a new iMac.
Oh, that's gonna be so awesome,
I really want a new iMac,
dude. Those new iMacs look so good,
dude. You need to get him to give you a free iMac.
I'm really annoyed if my Mac Mini is like broken and I need a new Mac. That's like a real problem.
Dude, what
My
percentage
Mac
of
Mini's
your
from 2011. It's like time though.
AJ? What percentage of your family budget do you think goes directly to Apple? And do you do that via payroll deduction, or how do you do it?
This is cool. This Marcus Brownlee video is cool. All right, I'm not clicking
Ruch,
on it.
What's your
Ruch, what do you
sidebar?
Yeah. So I'm reading this book right now called Barbarian Days. It's by this guy named William Finnegan, who's a very, very good writer. He won the Pulitzer Prize for this book, and it's just about it's a memoir. It's about his life growing up surfing, and so it's stories of him and his buddies kind of surfing in the 60s and 70s, kind of throughout his life. But I'm in kind of more of the section of his youth. But it's kind of a slice of life story in many ways too, because it's kind of California, like kind of West Coast culture in the 60s and 70s, you know, and the counterculture and how surfing was part of that for him. But
so give us a good like story from this that you won.
Yeah, so he starts the book talking about Hawaii, because his dad was like I want to say like a TV cameraman or something for various like TV shows, like, you know, drama series or whatever. And so the family got moved to Hawaii. And so he talks about how, you know, when he first got to the school in Hawaii, he didn't realize like how important like the gangs were. This was like middle school. And so, you know, he was getting picked on. And so eventually he joined this like group of white kids that were like protecting him. And, you know, sort of weeks later, he sort of realized that this was like the white supremacist gang.
Dude, that happened to Trump too.
but he was like, but you know, there was this really cute girl there, and I just loved talking to her, and you know, we just so
again it happened to Trump.
And so he just talks about how like so they would get in fights in school, but you know, then they would all go surfing, and it was sort of a kumbaya type of moment when they would go surfing, when there was no kind of like, you know, and if you were a good surfer, like the white supremacists were cool with you no matter what you were, you know. So there was this like, there was this Japanese kid that you know, was just an excellent surfer that, you know, basically he didn't become part of the white supremacist crew, but you know, everybody was cool with him because I was like, oh yeah, that dude's a great surfer, you know. So like there were things that transcended white supremacy and class and race and things like that. And one of those for him was or not for him, but for those other kids was surfing. But
wow.
that's a good random, just kind of little story from the book. But I'm like probably about 150 pages in. It's really, really good. It's to the theme of like reading things that we don't normally read, right? Because we're normally reading a ton of politics and law and things like that. So.
So on that point,
guys, can I say something real quick?
Hold on.
Oh yeah.
On
Steph
on
brought me
point,
an iced latte, and pretty awesome. Here I am, recording a podcast, and Steph's bringing me homemade iced lattes. Sorry, Tom.
No, go ahead. Tell me more about this iced latte.
So tell me, Ruch, what kind of cup is it in? Like a plastic cup or like a mug?
It's a glass cup. It's green.
It's green?
Green.
Yeah, tell me more. What kind of milk is in it? 2% whole milk?
It would be 1%. 1%.
Almond milk?
But
1% milk? What's the other 99%?
Well, that's 1% fat. milk fat. I think the rest is non-milk fat, I guess. I don't know. But the great thing about it is we have an espresso machine now. And so, we're just putting those capsules in, just making espressos all day long. It's amazing.
Rich, I think Tom was being facetious.
I know, but I was being facetious back. Tom, I'm sorry.
What was it? What did you want to say?
You were saying something important, Tom.
Did you guys hear? So, on a random topic, did you hear about this SEC lawsuit in regarding Bitcoin?
No, what's up?
So, the Securities and Exchange, I'm reading their press release from yesterday. Securities and Exchange Commission today filed fraud charges against the clandestine founder of a purported Bitcoin platform and chain of co-working spaces located in former bars and restaurants, alleging he bilked investors of both companies while hiding his connection given his checkered past with regulators in the UK. Do you guys know Renwick Haddow?
It's a great name.
Haddow.
Great name. I can see how he was
in New York.
I can see how he was so successful in raising money. With a name like Renwick Haddow.
This is what this is follow up from our Bitcoin episode, I guess. This is what I don't understand about investing in Bitcoin. It just seems so volatile.
Oh yeah,
it seems incredibly volatile.
I mean, that's it definitely is.
Maybe you should have thought about that before you did a whole episode on it. Now all of our listeners are like super long on Bitcoin, like their entire savings are in Bitcoin, and now you're mentioning that it's volatile.
Yeah.
Like when were you gonna tell the listeners?
This episode.
I mean, to be fair, like Ethereum's at 253. When we were talking about it, it was at 360. So if people just took our advice, they're only down like 30%. I mean, in a month, it's not the end of the world,
I think I need to restart my computer. I think the Bluetooth stopped working.
Did you hear about that though, Ruchit? Did you hear why that Ethereum
the flash
went down?
crash, man? I can't believe I didn't get in on that flash crash.
There were a couple of flash crashes.
Oh, really? I didn't thought there was just one.
The most recent flash crash was folks on this internet message board called 4chan. It created this hoax where the Ethereum founder was purported to have died in a car wreck, and the dude, and that's what caused this crash. And the dude had to post a selfie of himself proving that he was still alive in order to get the Ethereum.
Who's playing music right now?
I think it's AJ.
I am.
I think he's trying to play music.
AJ,
music that's off.
Is this your guitar that you're playing, or? Oh, I think I know what's happening. He's trying to play exit music. We're supposed to stop talking.
Yeah, he's trying to play us off.
Wow, this is like the stop speaking. You've already got your Oscar.
No, so usually when you guys start talking about Bitcoin, I like click around on Twitter or whatever. But my Bluetooth doesn't work on my Mac Mini, and so I don't have a mouse or a keyboard. And so I went to the second best thing.
Okay. All right. Well, we can call it an episode.
No, you guys keep talking. I'm doing great.
If we keep talking, will you edit it into the show?
No, dude.
Probably not.
AJ's not editing this in the show. Dude, I have to go.
Is your dad here?
Yeah, he's about to be.
Okay. All right.
Yeah, dude. But, dude, bring the family over, dude.
Dude, you don't even understand.
Dude, whatever, man. Like, just bring them all over.
I'll talk to you later, all right?
Dude. There's going to be lots of people's families here, Tom.
Yeah.
I mean, there's going to be lots of parents, dude. I mean, Jonah's parents are going to be here. It'll be good. It'll be good. But anyway, all right, dude. All right. I'll catch you guys later.
Later, AJ.
All right. Bye, AJ.
Oh my God, I can't stop the recording. I have to use my iPad.